The letter was never sent to me. Do you have it?
Good afternoon, everyone. This is the House Judiciary Non Civil Committee. We're here to consider two measures, although I think we'll probably be focusing on one primarily, and that's SR 146 by Senator Kennedy. This is the constitutional amendment addressing crime victims' rights. And Senator Kennedy, here he is. Let me invite you to come forward, and you can feel free to bring Mr. Poston if you'd like. And this is a hearing only. This is, as they're getting settled, this is an issue that came through the Senate last year, and we went ahead and engaged in some very productive conversations over the interim, primarily myself and the author several months ago, and then that was followed by some very productive communications between advocates on the issue in general, non-governmental organizations and interested parties, along with our prosecutors and specifically our DA's Association and DA Burt Poston, who's here with the author, Senator Kennedy. And I think as a result of those conversations, and there really were conversations, a dialogue, as opposed to negotiations, and I think what that has produced is a substitute that you have before you that I think represents a very positive jumping off point. There'll no doubt be tweaks and changes, as there inevitably are during the session, but I think the result of those conversations, that dialogue outside of the session, allowed for very productive progress on the issue. And I think, just speaking for myself, it's an issue that needs to move. It needs to move. It needs to be presented to the people in November. But the author and I had a very good conversation several months ago, and I think we agreed that before we go ahead and potentially chisel anything into the Constitution subject to the ratification of by the people, we want to make sure we've got it absolutely, positively right, and we don't want to do anything that would be that would unintentionally undermine the system as we have it right now and the ability for our court system to function and function well. And that's a balance, and it's a balance we strike here all the time on issues, and this is really no different. It's just that the stakes are higher on this because it is a constitutional amendment. We can't just come back the next year and fix it, as we do on some other issues. So the more time you take on the front end, the fewer issues you're going to have on the back end. And I think we're exactly where we need to be on this issue in terms of getting it done. So with that, let me recognize the author, Senator Kennedy, and the floor is yours.
Thank you, Mr. Chairman, and thank you to all the members of the committee for letting us present this today. I'd like to begin by saying I could not agree more with the chairman's comments about the history of this bill and this proposal and this opportunity that we have, and I am very grateful for the chairman's work that he has done, excuse me, and also the attitude that was taken from the very beginning about this. Chairman Golick recognized, as other members of this committee have recognized, that this is a very important issue for us, but it's also a very important opportunity for the state to move forward on something. I expect that the committee is going to hear perhaps from some witnesses today in support of Marsy's Law, and I would submit to you that you will be very moved by what you hear and will be moved to believe that we need to do something with regard to our victims' rights, how victims' rights are acknowledged and where they are embodied. We have a good victims' rights bill or statute, but this opportunity is driven by a philosophical belief that the rights of victims ought to be embodied in our Constitution. But as the chairman alluded to and stated very correctly and eloquently, how we do that is very important, and we need to be very careful about how we go about that. To that end, also by way of overview, this is not what this committee heard in 2016. Before I was involved in this measure at all, I understand that there was a proposal made, and this is very different from that and a very different approach. And also want to thank the chairman for all of his time to work on this bill, because quite frankly and admittedly, what we came out of the Senate with had some issues. And with a lot of mental sawdust being created and some good legal minds working on this, I hope that you will find this a very attractive and an improvement over the Senate bill that we presented, and is not as often happens, Mr. Chairman. Y'all take our bills and make them better, and you've done that with this, and I appreciate that.
We try our best. That's all we can do.
Thank you. I would also say that what you have before you is a careful, while the chairman said our conversations were just that, conversations. Beyond that, you had some important stakeholders that really got together and started negotiating on exactly how this needed to look and what would be the best way for it to present itself but be acceptable to everybody. And those wound up being two principal camps, if you will, the Marsy's Law supporters and those that have brought this as an opportunity and brought this to our attention in Georgia. And secondly, the prosecutors, the Prosecuting Attorneys Council, the district attorneys across the state. As I said in my initial presentation and involvement with this bill, no one fights harder on a day-to-day basis than prosecutors for victims. It's what they do. It's largely what drives them. And we commend them for that work. And so I appreciate their work, especially since it's come to the House and how they have moved forward in trying to figure out a way that this works for everyone. And my understanding is they have. In a moment, I'm going to ask District Attorney Burt Poston to speak to the committee. Lastly, I do want to thank a couple of people in addition to those that I've mentioned. Stephanie Woodard, who is a solicitor from Hall County, has put a lot of time into this. This is an important issue. She early on recognized the importance of this and value, and I appreciate, I don't know if she's here today or not, but I appreciate her efforts. And also PAC Executive Director Pete Skandalakis, who is with us today, and he too approached this in a very cooperative spirit. And which I think has allowed us to bring what is LC 298003 ERS. I hope, Mr. Chairman, that's the correct version that we have.
Has everybody got that? 8003 ERS. If you don't, please say something. Thank you. What
we passed out of the Senate embodied a couple of core beliefs, if you will, that philosophically, some things that victims of crime ought to have rights to. And that gets into the numbered paragraphs, but the beginning, in essence, talks about and speaks to the fact that victims of crime have a right to be treated with dignity and respect, and that beyond that, we get into what specifically rights do we want to give to victims and make sure that those are embodied in the Constitution, and they are the 5 items that are enumerated there, which is the right to, in essence, timely notice of a scheduled proceeding in which you are the victim. You have a right to be notified of that proceeding. That the right to also request a timely notice in the event that there's an escape of the accused. The right not to be excluded from any scheduled court proceedings involving the alleged act. The right to request to be heard at a scheduled proceeding, and then the right to be informed of your rights. The balance of the bill, and I'm going to ask Mr. Poston to speak to this, in essence addresses the enforcement mechanism. How does it work? And quite frankly, those are some of the things we really wrestled with on the Senate side, and I think it's been much improved, and I appreciate all the work. And if I could, Mr. Chairman, I'll ask Mr. Poston to speak in more detail.
Sure, let's just make sure that mic works.
Is that on?
I think so.
Thank you, Mr. Chairman, and thank you, Senator Kennedy. I agree with everything that's been said thus far. I came into this personally late last session and mostly between sessions and throughout this session working on it on behalf of the District Attorneys Association. And our goal in working with folks from Marsy's Law, primarily Brad Alexander on their behalf, was to preserve the structure of the original bill and the intent of the original bill while addressing some of the concerns that we had, making sure that we were as consistent as we could be with the existing statutory law. We didn't create any conflicts or any unintended consequences there. And so I appreciate Mr. Alexander and all the work that they've done in that conversation with us to get to where we are. So picking up where Senator Kennedy left off, I agree that the Paragraph A does kind of define who a victim is, who we're addressing, and what those specific enumerated rights would be. Those closely track the statutory language. And jumping off from that point, paragraph B then specifically states that a victim shall have a right to assert those rights, and that the General Assembly will provide the process whereby they do that by filing a motion in the criminal case. So in other words, if a district attorney is not providing notice as they should, if a court has gone forward with something, even if the district attorney is asked to continue it so the victim can be there, for example, if there's something like that that happens, that a victim would have a right to file their own motion and schedule a hearing and actually force their way to be heard and to have a voice in that process if they feel like their voice is not being heard. It further provides that if the victim is a minor child, if the victim is deceased in these kind of situations, that the General Assembly will provide a mechanism for a family member or representative to be able to stand in for the victim. And that's already present in statutory law now. That wouldn't require any additional statutory law. But it just makes sure that if a victim's not able to assert their own rights for whatever reason, that that appropriate representative will be able to do that on their behalf. And then paragraph C is a number of kind of the fine print disclaimers at the end of the advertisement that just make sure that we don't create any unintended consequences, that we don't create a private cause of action on behalf of victims where people are being sued, that we don't have victims appealing a motion hearing, for example, that would deprive the court of jurisdiction and bring the prosecution to a halt. It preserves the ability of the General Assembly to reasonably regulate the exercise of these rights and to deal with issues as they come up, and also preserves the ability of the court to maintain order in the courtroom, irrespective of victims' rights. Because while the vast majority of victims are good folks that have been victimized and that we work with in the courtroom, we do occasionally have people that can be disruptive or otherwise can be problematic and could potentially abuse the rights that we're trying to give them. So we want to make sure courts have the ability to maintain order on those rare events where something like that were to happen. So we feel very good about it. Prosecutors support this version of the bill. We're open, of course, to any tweaks or any adjustments that need to be made. I know that there are some concerns about a couple of the areas, a couple of places in the language, and we're certainly open to continuing the conversation about those and to improve it any way we can before final passage out of this committee. Beyond that, any questions, be glad to answer those.
Thank you, Mr. Poston. Any questions, members of the committee, for the author or for Mr. Poston? Mr. Coomer.
Thank you, Mr. Chairman. Just on that last comment, can you point out to us the areas of concern that you've heard about?
I know on the defense side, one concern, I think someone is planning on already speaking to this, but paragraph C 2A that says this paragraph shall not confer upon any victim the right to appeal any decision. There's a concern that there might be an independent right to appeal not created by this paragraph, but it is not excluded by this language, and that it might be better to move that out into a separate subparagraph stating just that the victim shall not have a right to appeal. And we would be amenable to that type of amendment if we can come up with that language. I don't think anybody wants a victim to appeal a motion to suppress, for example, or some other motion, and that to bring the process to a halt and the defendant sitting in jail. And I just don't think that's healthy for the criminal justice system. So we're open to that. I think Legislative Counsel had some concerns in paragraph A about the language right at the very end, the last line, line 16 in paragraph A, where it says such victims shall be afforded certain additional specific rights, including but not limited to. I think the word additional and the including but not limited to are probably unnecessary and might be confusing. I think there's some concerns about maybe those words need to be struck. Those are the two primary ones that I recall having concerns.
So, if I may, Mr. Chairman, so back to the first concern that was addressed on lines 40 and 41, help me out with this and correct me if I'm wrong. We're talking about language that's going to be placed in the state constitution here, or at least submitted to the voters for adoption. Is that correct?
Correct.
So this is not a statute that would be subject to tweaks and changes and corrections year over year, as we sometimes get into. But this provision as it is would leave open for the General Assembly to expand or restrict any kind of appeal it wanted to grant to victims in cases if this amendment is adopted. So the General Assembly retains authority
Correct.
to allow people to appeal if they believe that's the best public policy in the future.
Correct. We just don't want to create that ability in the Constitution where we could not then control it if it was creating a problem.
And conversely, if we change this language to say that appeals are not allowed, then we restrict the General Assembly from making public policy decisions in the future as to whether or not an appeal should be allowed.
Possibly so.
Well, I think it definitely would, because the General Assembly cannot enact legislation that's contrary to the
Correct.
Constitution. So we'd be tying our hands and tying the hands of future General Assemblies from making important public policy decisions about whether or not to grant certain appeals to victims in certain cases.
That could be the case. And I believe the defense.
I'm trying to help you out here.
I understand.
Well, the trick, I mean,
Yeah.
for lack of a better term, is to not necessarily, we're not looking to create more avenues for appeal while not tying our hands or not restricting ourselves later on if, in the opinion of 91 House members and 29 senators and the governor, that we want to go ahead and expand that from a statutory standpoint. So it's that balance point right there,
Right.
if I understand the gentleman's point.
That's exactly right.
Okay.
We're not restricting the General Assembly from statutorily creating opportunities for appeal for victims, but we are also, by this language, not constitutionally prohibiting the General Assembly from doing that in the future.
That's correct. I think there may be other people
Maybe I said that wrong.
speaking on that issue specifically that are more knowledgeable than I am. So,
Thank you, Mr. Chairman.
But that is the goal. I mean, I think just we can say that out loud, that's the goal, is to necessarily, we don't want to create more complications in terms of conferring specific rights of appeal through a constitutional amendment, which may, from a logistical standpoint, need to be undone at some point. That's what creates the problem with the constitutional amendment. By the same token, we also don't want to restrict the General Assembly's ability to statutorily expand on that if it sees fit in the future. Mr. Setzler.
Thank you, Mr. Chairman. I had a question on line 21 through 22, and if it's been addressed, forgive me. I did hustle over here from my other commitments. On the right not to be excluded from any scheduled court proceedings. What's intended here? I mean, is it they have access to sit in court and watch? Or is it they have a right to be heard in court, or is this something you want to be sort of spoken to generally and then fleshed out in statute? What's the goal there? Just that one right not to be excluded from any scheduled court proceedings.
that language tracks the current language in statute. There is a separate right to be heard on certain types of hearings, bond hearings, sentencing hearings, and things like that. The right not to be excluded is in the current statute. And there's specific additional language in the statute that says even if the victim is a subpoenaed witness in the case, which would normally under sequestration potentially prohibit the victim from being there to be able to observe the trial, that the court can allow that victim or should allow that victim into the trial. I think there's language that the DA should try to call that victim as early as possible in the process. But nevertheless, the victim is entitled to be there even if they're a witness in the case. And so that's further fleshed out in the statute, but basically the victim can't be excluded from proceeding even if they're a subpoenaed witness in a trial or at a hearing.
Mr. Chairman, I may have some questions later, but that's all I have for now, Mr. Chairman.
Mr. Bodie.
Senator Kennedy, for being here and bringing this important bill. I have two questions. Actually, when we're looking at the top of page 2, and we're talking about, I think it's line 29, we started to talk about the motion that the victim can file. I want to know if you all had the opportunity to speak with the Superior Court clerks of the state of Georgia, their association, because this is going to be kind of something new. I'm a criminal defense lawyer, and we never really had the victim able to file motions before. Typically, it's the prosecutor, pro se litigant, or the criminal defense attorney that files these motions. So, what is our Superior Court clerks and state court clerks? What are their position on that particular matter?
Thank you, Representative. I'm going to start and then ask
Okay.
Mr. Poston to speak as well. I have not contacted the clerk's offices, either
Okay.
the state or Superior Court, so I can't speak to that.
Yes, sir.
I do think, though, that the motion that is referenced herein, and this is something there was a lot of debate, a lot of discussion about the scope of what would be filed, where it would be filed, who would hear it, all of the things you're thinking of probably and talking about right now. But what's contemplated here is the motion is really limited to bringing to the court's attention that you've had a right that you have that's not been honored, it's been violated. And the
Okay.
purpose of the motion is to bring that to the court's attention so it can be dealt with properly and promptly. Is that
That's correct, and I've not spoken to the clerks directly. I know that the Superior Court judges have looked at this, and I don't want to speak for them, but my understanding is that if the prosecutors are agreeable to it, that they're not opposed to it, that but they have looked at it. Now, whether they've talked to their clerks or not, I'm not sure. One thing the bill does is it specifically states that the victim is not a party to the case in a general sense, but only to that specific ability to be able to file a motion and be heard concerning issues about their rights.
Now, some of my criminal defense colleagues want to know, in this particular hearing, and I know this is very touchy, will the defendant also be allowed in that particular hearing as well, where the victim is disputing or saying it's an issue with timely notice from the DA's office?
I don't think the bill addresses that.
Yes, sir.
My answer, I believe the way that would play out would be, I don't think the defendant, well, I think that would be in the discretion of the court.
Okay.
I think it would be driven by whether or not the court thought that the motion that was before it at the time and the issue it was dealing with did anything about the issue presented to the court touch upon or involve the defendant or the defendant's rights in any way, is how I think a judge would answer it. But I'm not a judge, so I can't say that. But I don't think there's anything in the statute that would be, or what's proposed, excuse me, that would be inconsistent with what I've just told you how I think it would work.
Yeah. And Senator, thank you for that response. I think we need to address that, because I know as a criminal defense lawyer, you might say, whoa, what's being said in there? Is it involving my client? Is it not? You know, I think we probably need to kind of address it somewhere, maybe a short one sentence, but I think that'll be important, because I can see a clever defense attorney making that argument.
Thank you.
Thank you, Senator.
Yes, sir.
Vice Chair.
Thank you, Mr. Chairman. Just kind of piggybacking on that, tell me if I'm right or wrong. The way I would see this is that if a motion were to be filed on behalf of a victim, would it be filed on the same case number as the criminal case number? And is that allowed? Is there any parallels here where third-party motions are filed under a criminal, a grand jury indicts a case or an accusation is filed and then it's given a case number? Is there any other scenarios where somebody other than the prosecution, or the state, or the defense can file a motion under an indictment or accusation number?
The one that I would think of would be a motion to quash a subpoena.
Okay, great
instance,
point.
we see this in child molestation prosecution, where the defense tries to obtain defects records, that sometimes defects' attorney will file a motion to quash in the criminal case, and that's, it gets scheduled, gets put on a court calendar just like any other motion would
Okay.
do. And in follow-up to the prior question, when this body passes legislation to amend the statute to provide a particular mechanism for how this motion is going to be filed, it could provide for note that the victim, when they file the motion, has to provide notice to defense counsel.
And then,
If
yeah,
defense counsel wants to be present, wants to be heard on that, they can take that up with the court prior to that hearing. I think that would be the way to address that concern.
and just to clarify, Representative Buddy, what you were essentially getting at was the right of the defendant to be in the courtroom if there's a motion by the, and so is it y'all's position that this could be dealt with statutorily as opposed to in the Constitution?
I think so.
Okay.
And that's something, and you're right, absolutely right, Vice Chair. I don't know if we can say it could be an in-camera hearing in the judge's chambers. I think we need to kind of flesh that out, because it's going to be a situation where a defense attorney, if they're not involved and they don't get notice, it can kind of, it's a lot of constitutional rights of the defendant may or may not be violated. So it's just a concern that I would like for us to kind of flesh that out a little bit.
Mr. Poston, you have any comment?
I agree. I don't have any problem with that. I certainly think the defendant has a right to at least know that this is going on and be heard about whether they should or shouldn't be at the hearing.
Can I ask this on this scenario that you just gave about a third party motion to quash a subpoena or for testifying or for documents or whatever? Does the defendant have a right to be present in those hearings? Is that right triggered in those kind of collateral third party motions?
They would. I mean, in every case I've seen, it's a defense subpoena that's being moved to be quashed. So I think they are typically present.
Now that we're talking through this, I've actually realized that I have filed a motion on behalf of a newspaper one time to quash a subpoena in a criminal case. So I filed a motion on behalf of a third party, and I did it. I'm answering my own question up here, but what I don't know is if the defendant had a right. He was there, but I don't know if he had a right to be there. And so I think that's what maybe the heart of what you're getting to, and we can figure that out in the next few days if it needs to be dealt with in the constitutional amendment or statutorily.
Thank you. There are no further questions. I think for the benefit of those who may have come in a little bit late, members, that we're jumping off on with 8003 ERS. That being said, I think this is an issue. I mean, 90-something% of what we do up here, especially on this committee, is not partisan. This is the issue. This is an issue that just begs for a bipartisan, consensus on it before we go ahead and put it on the floor, asking for 120 and then going to the people. So I think in this chair, you have to go ahead and think a couple of moves down. The thought of us amending this in committee after a motion is downright frightening from a what will this do to the measure, in terms of its ability to get to the floor. So I think we would do well to, if there are concerns, that we address them internally as a group to flesh that out sooner rather than later. Because what I'd like to do ideally is to, and I'll be doing a little shuttle diplomacy within the committee in terms of, has this issue been addressed? Has that issue been addressed? What we don't want to have happen is get to a motion and all of a sudden we have a real conflict. That just can't happen for the issue. So I'd invite members, if there are specific concerns, let's get together and talk about it and flesh it out and get broader on the consensus sooner rather than later. So, gentlemen, thank you very much. Appreciate it. Senator, you're excused if you want to be.
Thank you,
It's up
Mr.
to you.
Chairman, and thank you for your consideration and especially your comments about the timeliness of this, and I appreciate the committee's consideration. Thank you.
Well, thank you for your leadership on the issue.
Thank you,
Let
Mr.
me
Chairman.
call Stephanie Woodard as the Solicitor General of Hall County. Is Ms. Woodard here?
Chairman Gulick, she's not here.
Okay.
If I may, just briefly.
All right. And Pete Scanalakis is the DA of the Coweta Circuit. Is that right?
I am now the executive director for the Prosecuting Attorney's Council.
Well, I knew you were that, but I thought you were juggling.
No, I couldn't do both jobs.
My mistake.
I was DA for Coweta Circuit for 25 years. you know and the committee know, Mr. Chairman, that the DA's Association, the Solicitor General's Association, both support this bill, and we are willing to work with the committee and with Senator Kennedy. We appreciate all the work Senator Kennedy's done and all the advocates on behalf of Marcy's Law have done, and we're willing to work with everyone to make the tweaks in the language that are necessary to have this amendment go forward. And we thank you very much.
Thank you, Mr. Scanlakis. Is Mr. Tyson still in the room? Brian, did you? I know you had an issue. You don't have to speak to it now. If you wanted to get with us afterwards, I know there was some hallway conversation on that. It's up to you.
Yeah, we don't have any official position on it as an agency. So.
Okay, but you may have some suggestions from a language standpoint going forward.
Yes, sir. Just in terms of the logistics making it work, not to slow it down or
Sure.
just make sure we're all
Understood. Thank you. Thank you. Look, I mean, the sky's not falling, but if you can get that to us in the next day or two, that would be helpful. Great. Thank you very much. Ms. Tamiko Pugh. Ms. Pugh, welcome.
Thank you.
Just go pull that microphone a little bit closer to you.
Okay, can you hear me okay?
I can.
Okay,
I can.
perfect.
If we could ask you to limit your comments to about 5 minutes, that would be great.
Okay, I will
Thank
do
you.
that.
Not that you have to take all 5. Just want to.
Okay, thank you for the opportunity.
But you can.
Well, I'm Tamiko Pugh, and I am a strong supporter of Marcy's Law, and here's why. 10 years ago, I woke up alone in a state of confusion and panic, hopelessly lying in the middle of Interstate 85. Just hours before that, I had made a decision that I was finally going to leave my abuser. As I drove down the interstate, he sat in the passenger seat and threatened to kill both of us if I left him. The next thing I knew, he grabbed the steering wheel and tried to force the car into an accident, and we ended up on the side of the road. At that moment, he proceeded to beat me and strangle me to the point of unconsciousness. He went to jail that day. A few days later, I gathered the strength and the courage to go to file a restraining order. And as I walked into the courthouse, I was greeted by a familiar, very chilling voice that said, "Hello, beautiful." It was my abuser, who had just tried to take my life a few days before that. I was not notified that he was out of jail, so I kind of felt neglected by the system. I felt like I was kept in the dark. After that situation, I finally went back and filed a restraining order. He did violate the order several times. During that time, I was a real estate agent, and I just remember standing, waiting for my client to come and take a look at the home and the property that I was showing on that day. But needless to say, the client was my abuser. He proceeded to attack me and rape me. And that was the last property I ever sold. That was 10 years ago. As a victim of domestic abuse, I was stripped of the voice I so desperately needed to defend myself, my career, my children, my life. The criminal justice system, I feel, at that moment failed me. The lack of notification on the custodial status of someone threatening my life left me in a dangerous world that, despite my attempts, I could not escape. My story is a story of thousands of other Georgians, and it demonstrates the need to give crime victims constitutional rights just as strong as the accused. In some cases, this is a matter of life and death. And I'll just reference a situation that happened a few years ago in Macon, Georgia, Bridget Flowers. She was abused by her spouse. He was arrested and then released just a few days later, and she was not notified, and he shot and killed her in front of her children. And so when I say it's a matter of life and death, it is a matter of life and death. I could have lost my life. And so I stand here before you today as a survivor who was advocating on behalf of Marcy's Law, not for me because my case is gone, it's done and over with, but there are other people that will come after me, and I would hate to see them have to go through what I went through and what I experienced. It's not easy to stand up here. I'm literally shaking and trembling. I speak for a living, but this is very difficult. But at the end of the day, I just want to make a difference, and I want to make sure that crime victims have constitutional rights. The scars of domestic violence are many times hidden, and so if you look at me, you can't see my scars, but I have internal scars. I have emotional issues that I still deal with. I have bouts of depression. And so you can't see my scars. But with me today is one of our friends, and she's a survivor of domestic violence. Her name is Christy Sims. And Christy, if you don't mind, could you stand up? The face you see on her today was not the face she was born with, but it is the result of 13 reconstructive surgeries over the course of 2 years after her boyfriend purchased industrial-grade drain cleaner containing 93% sulfuric acid and poured it into a large bowl, lured her into the bathroom, where he doused her face with it. She has burns on over 20% of her body. After she came out of a 2-month coma, she had to fight to even get her abuser arrested and charged with the crime. It was not until she was actually went to the press and her story became known that her case was finally reopened after 2 years. After 2 long years of living in the fear because her abuser was still walking free, he finally was sentenced to 20 years in prison. Her life has been forever changed, and she is scarred and disfigured for life because the criminal justice system failed her. So how many more times will we allow this to happen? I support Marcy's Law. Thank you.
Thank you, Ms. Pugh, for your comments, and to Ms. Pugh and to Ms. Sims. It takes a lot of courage. It takes a lot of courage to come down here and do what you just did. Please don't think that we don't know that. We do know that. And to your point earlier about, you want to make a difference, I can assure you, you are in the process of making a difference. So thank you to both of you for your courage again. The Reverend Jackie Newsom. Reverend Newsom. Welcome.
I know that I look 12 years old, I promise, I really am.
Embrace it. Embrace it.
And for the sake of full disclosure, I'm also a licensed attorney in the state of Illinois and Georgia. I'm just magic, really. But I wanted to speak today and just talk a little bit about my concerns with regard to restorative justice and children who are affected by this resolution.
Can I ask you to pull the microphone a little bit? It's a little temperamental. Try again.
Can we hear me?
Is how about now? Go ahead and speak. No.
Is it on?
Yeah. Oh, yeah. It's on. Is around the bottom? There should be a little switch on the bottom of the microphone. Staff's going to go ahead and say the magic words, hopefully. Just have that switch on the bottom there. Yeah. I'll tell you what, let's go with something we know works for now. Do you mind coming to the table? More comfortable. Oh, there he is. Thank you, Mr. Wasatowski.
Thank you. Okay, we can hear me?
Yes, thank you.
Awesome.
Sorry for the delay.
No worries. So I just wanted to talk or share some of my concerns from a restorative justice perspective, and certainly from a Christocentric ethical perspective. So to the extent that we believe one of the goals of criminal justice reform is to bring victims and offenders back into restored relationship I worry that this resolution will ultimately make that difficult to attain. The danger here may be that victims never get to learn about the real change offenders have made over time, that victims never get to engage in restorative relationships with offenders, relationships that may actually help some victims in the healing process. Now, as a chaplain at Lee Arundel Women's Prison, I had the opportunity to interact with women, guilty women. And one of the things that was reiterated to me was this desire for them to apologize to victims, for them to show victims how they have changed, for them to offer their help and support to victims and their families as an effort to restore as best that they could the lives that they had affected. And so I'm just concerned that this may hinder that in some way. Now, from a morality perspective, as informed from Christian ethics, certainly that requires us to consider this bill, this resolution potentially in a different way. Victims have experienced real harm, and the ethical teachings of Jesus Christ require us to honor that harm. Those same teachings require us to forgive offenders and to allow victims and offenders who want to engage in restorative relationships. And so I just want to make sure we keep that in mind. Now, this truth is best seen in the biblical story of Jesus dying on the cross. Before he dies at the hands of those who have accused him of a crime, he says, "Forgive them, Father, for they know not what they do." And that comes from Luke chapter 23, verses 34. Now, shifting specifically to children who are defendants who are affected by this resolution, my concern is that children who are adjudicated as children for crimes are actually treated as adults when it comes to this resolution. Now, we know that the United States Supreme Court has encouraged us to remember that we are to view children differently, right? Specifically in Montgomery versus Louisiana, the court reminded us that we shouldn't penalize children perpetually for, quote, transient immaturity. And my concern is that this resolution may do that. In Miller v. Alabama, the court reminded us that for sentencing purposes, children should be treated differently than adults. That the imposition of the state's most severe penalties on juvenile offenders cannot proceed as though they are not children. And so I just want to make sure that we have a resolution that keeps in mind that children are children. And so we don't put them in a position where it is more difficult for them to be rehabilitated by this resolution. Now, of course, going back to the biblical principles, we know that there is an obligation to treat children as Christ treats us, to love children as Christ loves us. But not only that, the text in Matthew 18:6 tells us that we have to be extra careful not to put before children stumbling blocks that would cause them harm. And so I just want to ensure that this resolution is not creating a stumbling block for the children that are still loved, even though they're guilty in God's eyes. Thank you for your time.
Thank you, Reverend Newsom, for coming down and sharing your thoughts. Let me call on, is it Patrick and Patricia Cody? Am I reading that right?
It's close.
I'm sorry.
Close.
Patrick's, is it?
Patrix.
I'm sorry. Patrix and Patricia Cody.
Yeah, and Patrika. Japanese.
All right, I managed to get both of those wrong. I apologize.
Okay.
Welcome.
Thank you. Thank you for having us. Thanks for this opportunity. This here is a picture of my brother when he entered into the military. And we would like to share our story with you. We won't be before you long. But I am Patrika Cody Eberhardt. A few short years ago, our brother Watanabe Cody, a Gulf War Army veteran, was murdered while being a good Samaritan. He was helping a lady who had fled New Orleans after Hurricane Katrina and was offering her transportation to and from work. He volunteered to pick her up daily and drive her to work. And as our brother one day went to pick her up, her landlord answered the door and murdered him in cold blood. He shot him 8 times. Simply because he did not want to be bothered. He didn't want anyone to knock on the door. The perpetrator who killed our brother was arrested, but was released on bond without our knowledge. We were not told of bond hearing, so we weren't present. The only way we found out that he was released on bond was when we ran into him at the mall. My sister ran into him at the mall. During the time, the hearing in the beginning, he threatened our family and he mocked us in the courtroom. Finally, after about 2 years out of prison, he was convicted for 20 years in prison. But within 4 months after the conviction, he was released. Again, we were not advised that this was going to happen. We only found out by searching online. I took up the time to search online to see where he was in prison, and that's where I seen where he had been released. We were never notified to know the reason behind the release. Our brother, he was an Army veteran who served his country heroically in the Gulf War, yet the man who murdered him in cold blood and stole him from our lives is walking the streets, a free man. Because we were not informed of the bond hearing and the subsequent release of our brother's murderer, we felt unprotected. We felt as though our brother's murderer had more rights and was protected by the judicial system at a higher level than our family. That's why we support Marcy's Law and equal constitutional rights and protections for crime victims, so that this doesn't happen to any other families in Georgia. And I'm holding a picture. This is my brother and his son. He had one son when he departed from the Army. His son is now 22 years old. He just celebrated his birthday, and his request was to send his father's ashes to him. He didn't want money, he didn't want toys, he didn't want or a car or anything, but he requested his ashes. So this is dear to our hearts, and I hold a picture of him holding his son when he was just a baby. So he will never, ever have a father figure, but he will deserve the right to have justice, and we support Marcy's Law.
Ladies, thank you as well to you for having the courage to come down here. Let me ask you a question, if you don't mind. That your brother's murderer was sentenced to 20 years?
Yes. Mm-hmm.
Do you recall if he pled guilty to murder, or if he pled guilty to somehow a lesser charge?
He pled to a lesser charge.
I see. And what county was that in?
DeKalb County.
I see. Thank you very much for your time and your courage coming down here.
Thank you for your time. Thank you.
We'll get it done. I promise. I see no other witnesses have signed up. I want to thank members of the committee and the audience here who are interested in the issue for taking the time to come down here. We appreciate it. Members of the committee, we're going to go ahead and we'll use, again, 8003 ERS as our jumping off point. Let me ask you if you could. I think the most efficient thing would be to get any suggestions in writing, to send them to myself and copy Mr. Wasatowski as well. And we'll put those together, and we'll work with Ms. Travis on, as well as the author, Mr. Poston. I know Mr. Tyson had an issue that he wanted to address, but the sooner we can get that together, the better. That'll allow us to go ahead and come out with another sub. We'll circulate that electronically with members, and with the intent of scheduling another hearing, potentially to go to a motion, just depending on how that conversation, that internal conversation goes. One administrative note: we will likely have a meeting tomorrow afternoon, right after lunch. It'll be on technically on House Bill language. It's going to be House Bill 1006 by Chairman Setzler. It is language that is related to House Bill 32 that we addressed last year, which was Representative Chandler's bill, having to do with underage sexual molestation, child sex molestation in the school setting. I know it's an issue that we've wrestled with for the last 2 or 3 years in terms of getting the language right. Chairman Setzler has asked for a hearing to consider his language for the committee's approval or for the committee's consideration. as a possibility of taking that language and amending it to a Senate bill to be determined later and sending it back, again, under the assumption that the committee can come to a consensus on that language. The first step in that process is to consider that language in House Bill 1006. So I just wanted to go ahead and set the table on that. You'll get the notice on that later on this afternoon. And with that, we're adjourned. Thank you.